Hello everyone, welcome to Legal Darshan. In this video, we are going to discuss the third topic of part 8 of the Code of Civil Procedure, which talks about reference, review, and revision powers of a court. So, like the past two topics of revision and review, we are going to discuss revision this time. Any order in the CPC is not supporting the provision that is laid down in revision, like the previous two topics. Reference and review, along with their respective sections, were supported by Order 46 and 47 of the Code, but revision is only dealt in Section 115 of the Act. It reads that the High Court may call for the record of any case which has been decided by any court subordinate to such High Court and in which no appeal lies thereto, and if such subordinate court appears to have exercised a jurisdiction not vested in it by law, or to have failed to exercise a jurisdiction so vested, or to have acted in the exercise of its jurisdiction illegally or with the material irregularity. So the conditions of this section is that the matter goes from the subordinate lower court to the High Court for revision within 90 days of the decision given by the subordinate court. The case which has been sent for the revision must not be appealed before that High Court previously. That is, no appeal should lie, and the revision matters are only taken in the consideration where there is a faulty jurisdiction. It has been provided in this section that the High Court will not vary or reverse any order or any decision that has been laid down in the proceeding if there is no faulty jurisdiction detected. Its subsection 3 reads that a revision shall not operate as a stay of suit or any other proceeding before the court where such suit or other proceeding is stayed by the High Court. So the High Court must mention it or must express it explicitly that there is a stay on the proceeding, unless and until the stay will not be taken as a stay on this suit impliedly. So what are the conditions for this revision? Number first, court can take the suo motu cognizance, the High Court, or by the appeal of parties under revision within 90 days of the decision given by the subordinate court. Revision may lie, but there must lie no appeal against the decision so passed by the subordinate court. There is a small disclaimer that the content I have used to mention the conditions of how a revision can be applied. What are the conditions under which revision can be applied? I have studied it from legalservicesindia.com, so I am mentioning the same points and also providing the credit to them in order to violate any copyright issues. Yes, in continuance, so here are the conditions so mentioned: that there must lie a case decided. Without the decision, one cannot go for revision, and there should lie no appeal against the decision given in the subordinate court in the High Court. There must be an error of jurisdiction, that is, the subordinate court has failed to exercise its jurisdiction, or it has exercised a jurisdiction which it is not allowed for, or it has acted in the exercise of its jurisdiction with material irregularity, or have done some act with illegality. Now the High Court cannot vary or reverse the decision so made by this court, and the High Court will only take the cognizance of this power, of this revision power, where there is a case of faulty jurisdiction. That is, revision cases can only be taken up by the High Court where there is a fault in jurisdiction, where there is any substantial question of law, or where there is any conduct of the court which is not an irregularity in its jurisdiction. The High Court cannot take the matter in its cognizance under revision, that is section 115 of this code. The High Court will not enter into the evidences or into the research or into the merits of evidences in the matter. It will only come into the picture where there is faulty jurisdiction. It was so held in the case of Dinshaw Ironwork. The case of Rajaram Nathuji also held the same principle, which said that the High Court cannot interfere in the matter even if there is an erroneous decision made by the subordinate law, until and unless it is a matter of faulty jurisdiction. So the High Court is not allowed to interfere under this provision until and unless there is a faulty jurisdiction. So this section binds High Court to only come into the picture to keep a check whether the order or decree of the subordinate court is held up in its jurisdiction, that the case is one in which the subordinate court has vested jurisdiction, and that if the court has jurisdiction, it has not acted illegally or with material irregularity. If there is no fault in jurisdiction and there is a decision by which the parties are not satisfied, they can also go through other modes such as appeal, such as reference, such as review, but the gates for the revision provision is closed for the High Court to decide in such matter under this section 115 of the Code of Civil Procedure. With this, we finish off our part 8 of the Code of Civil Procedure. However, there is a point I would like to mention, that the section and its provision of revision nearly associates with one kind of writ. Which is that kind of writ? You need to mention in the comment box below. Also, if you like this video, please like, share and subscribe, and don't forget to share it with your friends. For any other queries, feedbacks or suggestions, please feel free to contact us at legaldarshan@gmail.com. Stay tuned with us for more such legal content. Thank you for watching this video. Have a good day.